Well, President Obama with some comments on the Supreme Court yesterday that's making some headlines today. He predicted the justices will uphold his health care law, even as he said overturning it will amount to judicial overreach. Take a listen.
Ultimately, I'm confident that the Supreme Court will not take what would be an unprecedented, extraordinary step of overturning a law that was passed by a strong majority of a democratically elected Congress. And I just remind conservative commentators that for years what we've heard is the biggest problem on the bench was judicial activism or a lack of judicial restraint, that an unelected group of people would somehow overturn a duly constituted and passed law.
Well, this isn't the first time the president has challenged the high court. You may remember back in 2010, his State of the Union address after the high court overturned campaign finance restrictions in the Citizens United decision. He said this:
with all due deference to separation of powers, last week the Supreme Court reversed a century of law that I believe will open the floodgates for special interests, including foreign corporations, to spend without limit in our elections. I don't think American elections should be bankrolled by America's most powerful interests, or worse, by foreign entities. They should be decided by the American people. And I'd urge Democrats and Republicans to pass a bill that helps correct some of these problems.
Joining me now, Fox senior judicial analyst Judge Andrew Napolitano. Already shaking your head a little bit. Judge, what do you make of the president's comments?
Well, look, the president is entitled to predict that the Supreme Court is going to uphold the statute. The president is entitled to make a strong constitutional argument in favor of the statute. But when the president questions whether or not the Supreme Court has the authority to invalidate the statute, the president railing against unelected people invalidating what has been enacted by Congress belies the history of the country and the president's education of that history.
Wait a minute. Are you saying this is the first time we've seen a president challenge the court in such a way?
No. It is not the first time we've seen the president challenge the court. It is the first time since Andrew Jackson that the president has suggested that the court doesn't even have the ability to overturn what Congress has enacted and he has signed simply because they are, quote, unelected. The president is a graduate of Harvard Law School, where he was the chairman of the Law Review. The president is a former instructor in constitutional law at the University of Chicago Law School, two of the best law schools in the country. He knows that this is our system. It is our system that unelected, life-tenured judges get to decide what the law and what the Constitution mean, and they have the power to invalidate what the Congress and what the president does. That they have that power was challenged by him yesterday for the first time since Andrew Jackson in 1835.
The president said that if the Supreme Court overturned this health care law, it would be an unprecedented and extraordinary step. Is that accurate?
No. And that's why a lot of us who watch this for a living, whether you believe this statute is constitutional or not, are so animated by what he said. It absolutely would not be unprecedented for the Supreme Court to overturn an act of Congress. The Supreme Court recently overturned an act of Congress which made it a crime to bring guns within 1,000 feet of schools under the Commerce Clause because the Supreme Court said bringing a gun near a school is not an act of commerce, it's a crime. And the states can prosecute this far better than the federal government can. That was a duly enacted, popularly enacted, bipartisan supported piece of legislation that the Supreme Court invalidated because it found that Congress didn't have the power to do it under the Constitution, and President Obama knows this.
Now, some would suggest this is an election year. This is politics at play. And the tension between the executive branch and the judicial branch is actually a good thing, that we want to see tension between the different branches of government. That's our government working. What would you say?
I would say that politically, the president, if he loses this, let's just say hypothetically, Jenna, it's a 5-4 vote invalidating the individual mandate. And let's say the 5 justices were all appointed by Republican presidents. then President Obama probably could make some political hay out of this during the campaign by railing against Republican appointees to the court. But he cannot, with intellectual honesty, suggest that they don't have the power, the authority to invalidate it. He could say it was political. He could say they were wrong. But he cannot say that they are without the authority to do it.
Some important insight for us today, Judge. Thank you very much, as always.
Pleasure, Jenna.